next week is Mark Reinhardt on conflicts of interest, and the week following is Scott Smith, our rescheduled colloquium from the University General Counsel's office on medical marijuana in Utah. So that's the last thing. And I'm just going to catch my breath. I was silly. I ran down the hall because I was late. So it's my great pleasure today to introduce to you Professor Ubaka Ogbogu. He's from the Faculty of Law at the University of Alberta in Canada, where he specializes in health law, particularly involving such things as consumer protection and stem cells. He received his law degree from the University of Benin in Nigeria. Interestingly, law is an undergraduate degree in English-speaking countries such as England and Nigeria, so that he was fully licensed to practice law at the age of 22. Practiced law for several years in Nigeria, then got a master's degree at the University of Alberta and a doctoral degree in law at the University of Toronto. And he is now, as I said, on the Faculty of Law at the University of Alberta to the north, and will be speaking to us today on dead letters and stem cell markets, how to protect consumers. So without more.
Thank you, Professor Francis. I'm happy to be here. This is a wonderful place. We've got German glazed windows. I heard about that. And really lots of great space. It's a wonderful building and a wonderful place to be. People here are so nice. I thought we were nice in Edmonton. I've experienced the next level of niceness in Salt Lake City. Well, thank you for coming to the talk. I'm going to speak for about 45 minutes to an hour. I always promise that, but who knows where this is going to go. But that's my target. And I'm going to talk to you about stem cells and consumer protection. I'm going to make a big argument, really, that's what it is, a big argument for something. And I hope some of you would agree with me, and those of you who disagree with me, I always welcome a challenge. We can talk about it. I assume everyone here has some familiarity with stem cells. Know what they are, in general. Okay, so I'm not going to go into that. Then your body, stem cells. Okay, so I'd like to start with some conclusions. I always do this so you get a sense of where I'm going, and if I run out of time, you at least know where I'm going. So I'm going to make 2 points. So I'm going to lead us up to 2 points. The first is that when it comes to marketing and promotion of unproven stem cell therapies, so out there right now, as I'm going to show you in a second, there's lots of treatments out there that are labeled as stem cell treatments, and they're not scientifically proven to be treatments that are safe or effective, and they're also not approved by any health regulator in the world. Those are the two things to watch out for. The treatments I'm going to talk about are going to be treatments that are not approved by any health regulator, or treatments that have not been shown scientifically to provide the relief that the persons who are promoting them claim that they provide. So I'm going to argue that this is primarily a consumer protection issue. And specifically, did I do that?
You jinxed it.
I jinxed it. Okay. It's a cool feature, though.
Yeah. It just sort of appears every so often.
Don't know why.
Yeah, I heard about that.
It's the cloud.
Yeah. All those things I said about the building.
Yeah.
All right, so I'm going to argue that contrary to what you're going to read out there from people who study this issue, where they pitch it as a product regulation issue and they call on the FDA to do something, I'm going to argue instead that this is a consumer protection issue. And for all intents and purposes, it's better to view it that way because you're going to get more robust enforcement a more robust regulation if you go the consumer protection route. Typically, what you see in all the things that have been written on this subject, all the articles and all the things out there about it, is that it will be pitched as if the FDA should play a lead role. They'll mention consumer protection, specifically truthful advertising, at some point, but they bury that lead. I think consumer protection is the lead, and that's the second conclusion. They're more robust and effective tool compared to either regulating the products, the stem cell treatment themselves, or the conditions or pathways to market entry. This argument is both a legal and practical argument, as I'm going to show, using two cases that actually come from the US. We have some US case law on this to illustrate that what I'm suggesting here is the better way to do this. Okay, the structure of the talk, I'm going to start by describing what I mean by stem cell markets. That's going to be about 10 minutes. I'm going to just rush you through it. And then I'm going to talk about the FDA pathway, this product regulation pathway. And I'm basically going to criticize it. I'm going to say it is not effective, and I'm going to tell you the reasons why it's not effective. And then I'm going to focus on what I think the lead should be, which is consumer protection using truthful advertising laws that require persons who put claims out there to ensure that those claims are true. That is the FTC, the Federal Trade Commission's jurisdiction in the US. And in Canada, we have the Competition Bureau that deals with that as well as regulator. I think that's their purview. Now, they're not doing as much as they should be doing in relation to this matter presently. So I'm not saying that they're being effective. I'm just saying it's an effective means of regulating the issue. So stem cell markets, what do I mean by that? First thing you have to know, as I said before, stem cell treatments exist. However, for the treatment to be considered to fall within what I'm going to describe today, it has to be a treatment that has not been proven scientifically to work, or one that has not been approved. Health Canada, I'm Canadian, so I'm going to make references to Canada from time to time. I know Americans don't like that, but you can deal with it for one day. So Health Canada and the FDA have approved some stem cell therapies, mostly for solid tumor cancers and for blood cancers. That's not included in my talk today. You're not going to find these treatments in any of the clinics that provide or sell or promote these unlicensed stem cell therapies. They've also issued conditional approval for a stem cell treatment to treat graft versus host disease in children who have gone through cancer treatment. That is also not part of what I'm going to talk about today. Stem cell treatments are actually the standard of care for bone marrow transplants as well. That is also not included. That is standard of care. It's clinical practice right now. It's used in the clinics. That's not included in what I'm going to talk about today. There's lots of research going on stem cells and how to use stem cells in medicine. But all of it is just at the research stage right now. My guess is before we start to see stem cell treatments in the clinic, it'll be 15 to 30 years out, if it even works. I think something that people sometimes forget is that not everything that is being researched leads to a treatment. And we might never actually see stem cell treatments. I am a pessimist by nature, so that's why I said, but my sense is, even if we do see stem cell treatments, it's going to take quite a while before it comes. If you just think about the path that from research and development to clinics, that's it's a long and narrow road, and I just think stem cell treatments will be standard of care for a long time. But if you know anything about stem cells, you know that there's a lot of hype about stem cells. It is being seen as the thing that's going to change medicine. It's the magic bullet, the cure for everything, essentially. And some clinics and individuals have used this hype to build a market around stem cells. They provide what they claim to be stem cell treatments, and they provide it and claim that it can cure essentially everything. And this is a market that is now fully established in the United States, in Canada, and in many other countries. Now, the first time we observed this is a paper that I published with some colleagues of mine at the U of A. We started to observe this around 2005, so we decided to do a study. And what we're seeing at the time were reports about lots of clinics outside of North America that were offering treatments to patients, which they claimed to be stem cell treatments. And they were offering these treatments mainly to North American consumers. So patients from North America will travel to places like China, places like Russia to receive these treatments. So we decided to study the market as it existed at the time. And what we did was to do a content analysis of websites where providers claim to be providing stem cell treatments. And they were doing this in a direct-to-consumer fashion. And that is something you're going to see that's consistent through all the studies of this. There's no middle person. They sell it directly to the consumer. They advertise on their websites and they say, come and we'll give you these treatments. So there's no regulator between them and the consumer. They're just going directly to the consumer. So this was a study we published in 2005, which pitches this as an advertising problem. We noticed it that early, because in the study we didn't actually go to the clinics. We don't know what they're providing. It could be saline. We don't know if they actually have stem cells, if they know how to, get stem cells or use them in treatments. But they claim to be providing stem cell treatments for all kinds of conditions. So it was the very first study on this. And then sometime around 2016, this was an article in the Boston Globe. I believe that's what it's called. Boston Globe, right? Okay, good. And this was a story that ran in Boston Globe about stem cell clinics booming in the US. Prior to 2016, you had some American presence in this market, mainly through brokers who will connect you with these clinics in places like China. But this was the first time we saw a report saying we now have as many as 170 clinics across the US. So some of our friends, Lee Turner, who's at Minnesota, is a bioethicist, and Paul Knopfler, who's a stem cell scientist at UC Davis, decided to do a study to just get a sense of what the US market is like. That map shows you what they found. These are the clinics and providers in the US as of 2016 when they came out with this paper. They took a different turn in terms of how they saw the role of regulation here. They immediately latched onto the idea that the FDA has a role to play in this. So they said, look, the FDA has to get in here and control what these clinics are doing. I think this was a very popular, very, very well-known study. It was a big hit when it came out. And I think this was quite possibly a mistake on their part. I don't think they thought through this very well, because the minute they said this, and the minute they pitched it as a product regulation issue, everyone just started to repeat that. It's a product regulation issue, the FDA has a role to play. And they've been on that, and they've actually managed, Lithona especially has managed to get the FDA to actually do something about this. Single-handedly, he's been really an advocate for the FDA getting involved in this. And so he's managed to get the FDA to send some warning letters and take some action. But I just don't think that's the right path for reasons I'll explain later. He followed up with a study in 2018 where they found that 90 to 100 businesses appear per year. So this is now, you probably have as many of these in the US now as you have regular clinics. These businesses advertise the kind of stem cell treatments we're talking about. Again, they talked about the FDA role. It's again about the FDA. So that's the consistent messaging you're going to see. This is a paper that came out from every name you want to see on this issue in 2018. And they surveyed the literature, they looked at policy options, and again, the lead is the FDA and Health Canada, Food and Drug regulators, asking them to do something about it. They do acknowledge that this is not the only solution, but they don't emphasize the other solutions. It's very clear that what they're asking for is for the FDA to play a role in this, and for Health Canada, which is the equivalent regulator in Canada, to play a role. They mention consumer protection, but I think they only referenced my paper because they didn't invite me. Made me happy. I wasn't available. They referenced that, but again, they buried the lead. It's not the lead for them. They didn't consider consumer protection to be about this. Okay, so here's a study I did with two of my research students. Just to describe the Canadian context, again, I'm Canadian, so I have to talk about Canada a bit. We found that physicians are actually the ones who dominate the market in Canada, which is interesting. You now have physicians who are trained medically providing these treatments. I met one at a conference, one from the US at a conference in Canada. He came to the conference, it was a stem cell conference. He came to the conference to learn about stem cell science. But he offers the treatments in his basement and invited me to his clinic to visit. And I said, no, I don't go to clinics in basements. I may never come back. But anyway, so physicians dominate this market in Canada, we found. Now, where it gets really interesting in the Canadian context is that we thought initially after the study that physicians were doing this surreptitiously, that nobody knew that they were doing this. It turns out that the College of Physicians and Surgeons in Alberta, which is the province I live in, actually allowed them to do this. And the reasons will become apparent later when I discuss the FDA's role, but the college allowed them to do it as part of something called clinical practice. So they had gone to the college and college said, oh, fine, doctors can innovate in the clinic. You can take stem cells, and so long as you're not making a product, you're simply using it to help your patients, that's fine. And the college, which regulates physicians and surgeons in the province, did not bother to actually check with Health Canada. Health Canada learned about this after we published our study, and then claimed authority over the whole thing. Said, look, we regulate cell therapies of any kind as drugs. You shouldn't be doing this. Don't do this at all. But Health Canada only acted after our study came out, indicating that physicians were doing this. Up until that time, this was up until last year, physicians were doing it without any regulatory checks. Lee Plana, who's also Canadian, who works and lives in Minnesota, did another Canadian study where he found 30 Canadian businesses that provide stem cell interventions at fertility clinics. So in a nutshell, this is everywhere. It is in North America. You can get stem cell treatments right now. I'm sure there's a ton of them in Salt Lake City. You can walk out of here now and find a clinic and get stem cell treatments. We've also found that not just physicians are involved in this. Alternative practitioners, so homeopaths and naturopaths are also involved. This is a study done by some colleagues of mine, and they found 243 websites that offer these treatments. Again, all of this is being offered direct to consumer. And 208 US-based clinics and 7 in Canada. So a ton of them in Canada, a ton of them in the US, and fewer in Canada. What do they actually offer? They offer all kinds of stem cell treatments. They offer stem cells taken from you, taken from others, taken from animals. They get stem cells from everywhere. They even advertise stem cells, some kind of stem cells called induced pluripotent stem cells. If you know anything about those stem cells, they shouldn't get anywhere near you. There are stem cells that are at a very early stage of research. You shouldn't be using this at all in a clinical context. They also offer those for treatments. The clinics typically offer a cure for everything. Literally everything that ails humanity can be solved by stem cells. So wide range of diseases and injuries, everything, aging is even one of the indications. So they offer anti-aging, facelifts, breast augmentation, anything at all. They don't discriminate. If you have a medical problem, curable or incurable, you get stem cells. And they also target some populations especially. So they target people who are likely to be vulnerable to this kind of messaging. Patients or parents or guardians of minors with autism or cerebral palsy. They target those who act through proxies. So persons who have Alzheimer's or other kinds of neurodegenerative diseases. You can see sort of what the marketing is about here. They market in a very specific way. They portray the treatments as clinically well established. Not even Advil is clinically well established. But the message you're going to get from reading these websites is that there's no risk to this. It is all good. And they don't usually provide evidence, if at all. When they do, it's usually testimonials. So they'll have patients who in videos and don't discuss risks at all, or let's say the risks are you're going to get a headache, and you have a fever, and you're good. Now, this treatment, as I said before, are proven and unapproved. Here's some examples. Besides the clinics, you also have some offerings out there. For those of you who might be interested in just like sitting at home and ordering some, this is a White Embrace stem cell soap. It is age-defying, which I guess is a good thing. I don't know about the name though. And you can get it as a full set, everything included. They say it's better than whatever that is, and placenta. Is anyone here using placenta?
Kardashians.
Yeah, they might want to get on this. I mean, if you look at this, it has, yeah, it looks great. The packaging is very sciencey. It's got that sciencey sounding thing over there. This looks great. I'll use it. I read Cosmos sometimes. Don't even judge me about that. If I didn't read it, you wouldn't see me put this up. But I found this in Cosmopolitan, and this was been advertised by Julia Roberts, I think. Was on the other page, and it's the future of skin rejuvenation. Yeah, this one is made from your own stem cells. So you give them your own stem cells, yeah, and they just make you. It's autologous, and they make you a nice product for your skin. This one is from animals. This stuff is all out there. You just Google it. You'll find stem cells. This is my favorite. A friend sent me this. This came in the mail. It's a capsule. It is risk-free for 365 days. It's made for you postage paid. And it's a powerful liquid capsule. It regenerates all your vital organs. All of it.
Indiscriminately.
Yeah, like just
vitamins.
right. I think it's probably just, I don't know. I'd like to try this one. I feel like my vital organs need vitalization. All right. Okay, so you can get a sense here. Now, I can talk about how we got here, but I don't have time for that. So we're going to park that. These are some burning questions that you might have now. How did this happen? I have slides for that, but we're not going to get into that today. So we might have a so what question. So what? Well, I have an answer to that as well. This can be very harmful. And in fact, there's evidence that it's harmful. But I'm not going to get into that. That's going to distract us from my purpose today at least. So if you have questions about this, I'll be happy to talk about them in the question period. But I'm going to park them for now. But the thing you should know is we got here mainly because of the hype around stem cells. And in terms of dangers, this can be really harmful. There have been reports of people being harmed by this. It is financially harmful. It can harm your person. It is harmful in all kinds of ways. What I want to talk about instead is what I call the dead letter problem. Now, we live in countries where we expect these kinds of things not to happen. We have laws for this, and this is where I start from. It's not really a matter of whether you believe this works or doesn't work. It's a matter of the fact that we've made laws for this exact kind of thing, for where people take advantage of hype and build a market that's based on something they cannot show to be true. This is not a new problem. This goes back to centuries ago, to where people did bloodletting and sold all kinds of remedies as cure-alls. And we made laws for that kind of thing. In the US, we have laws that are enforced by the FDA, and we have laws that are enforced by consumer protection agencies like the FTC. So if we have laws, and this is the first philosophical question I'm going to drop with you today. If we have laws and they're not being enforced, then why do we need laws? It just seems to me like you don't need law if it's not having any role in society. I happen to think that one of the reasons why we have law is because we expect it to actually perform some kind of function that we cannot get to on our own without the benefit of the law. But if it's having no benefit, then it's a dead letter. We should get rid of it. We should accept that we're not living in a society where you can walk outside and get stem cell treatments. So that's the first thing. And it's a loaded philosophical question, and I'm not going to get deep into it, but that's kind of where I'm coming from with this. The second is, maybe there's something about the law that makes it difficult for it to be enforced. And if it's difficult to be enforced, then maybe we need to correct that. If it's not enforceable, we need to correct the reasons why it's not enforceable, or we need to find a more enforceable means of getting at the problem. If it's having a real impact on people, we need to solve it. We can't just give up. And so what I'm going to address today are two ways we can possibly solve this, and argue in favor of one because I think it's more effective. We can't let this be a dead letter issue. We can't just have laws that are not enforced. So a dead letter is defined in the dictionary as a law that has not been repealed but is ineffectual or defunct in practice. I think the laws we have, if they're not enforced, will amount to this. And what I have, and what I'm going to argue about next, is that there's a way we can avoid this problem. And another way we can get wrapped up in this problem because we're focused on the wrong thing. So I'm basically going to argue against the literature which says we should go the product regulation route and say instead, let's go down the consumer protection pathway. Okay, so what are my arguments against the FDA's role in this, or against the product regulation pathway? Now, as you all know, the FDA regulates food and drugs. That's a summary of their role. They also have some role in consumer protection and in truthful advertising. But that is a secondary role. They can regulate persons who mislabel products or who try to sell or promote drugs for purposes that have not been approved. However, the FDA first has to show that the thing that they're trying to regulate is under its jurisdiction. So they have to show it's a product that falls under its jurisdiction. So what they do primarily is product regulation. The same with Health Canada in Canada. Now, I think the limitations with this approach are as follows. The first is an argument that comes from people who have, in fact, tried to get around the FDA's jurisdiction. They've said what we're doing in these clinics is clinical innovation or clinical practice. We are not making products. We're taking stem cells from the patients and we're injecting it back into the patients. They compare this to IVF. They say in vitro fertilization was devised in a clinic. It never had to go through the FDA. We're doing the same thing. We're simply taking the patient's cells and we're refining it or spinning it and making it something more useful to the patient, and we're injecting it back. That is not a product, it's clinical innovation. So that's the first thing. Now, that comes because if you follow the literature on how to regulate the product of regenerative medicine, this is actually an enduring problem. Many jurisdictions grapple with what to call the things that come out of stem cell research and regenerative medicine. They haven't quite, they struggle with that, whether they are drugs or devices or things that we know already. In Europe, they've created an entirely new classification for these products. Recently in the US, the FDA has done the same, created an entirely new classification for the products that come out of this sector. The second is jurisdictional confusion. The other challenge that you see coming from people who want to get around the FDA's jurisdiction is they say, look, it's clinical practice. States regulate that. The federal government has no business. The FDA has no business regulating clinical practice. And that confusion, I'm going to argue, still lingers, even if the FDA has had some success in showing that this shouldn't be an issue. Right to try movements, another reason why the FDA jurisdiction is very limited. Right to try movements are movements where usually initiated and run by patients where they seek early access to experimental treatments that have not been approved or proven scientifically to work. These are patients who say we're desperate and it's our body, we should be able to try these treatments at risk to ourselves. So there's an autonomy argument that underlies that the right to try idea. So these patients say we have to try, and they've had political success in the US. In fact, they've actually managed to create legislation in the US. So it's not a movement to ignore. They've changed US law, and they've actually, this is something very difficult to do. Think about how many decades people have been trying to reduce the FDA's power in the US, and they haven't succeeded. This movement actually managed to change the FDA's jurisdiction. So it's a very powerful movement. And that's tied to the idea of legislative reform and political influence. This movement got to politicians, and politicians then created change. I also think the FDA has limited authority to regulate extraterritorially. That's an issue. It's also an issue in the consumer protection context, but I think the FTC has better connections than the FDA, is essentially the argument I'm going to make there. Now, the FDA's focus, as I've argued before, is on product safety and efficacy, not on marketing claims. I think marketing claims are secondary, and I'll illustrate that with the case I'm going to discuss. And that's also a limitation, because the FTC is in a better position, as is their primary responsibility to regulate truth in advertising. And then this is a big one. I'm not going to get into it today. All the reasons why people hate the FDA, issues with drug approval processes, how much time it takes, bureaucracy, the FDA is everywhere, mission creep, all of that stuff. All that provides a moral justification to actually challenge the FDA's authority. And that's why people will keep challenging the FDA's authority. If they feel the FDA is stopping them from doing what they're doing, they can always sell it as the FDA is overreaching, as usual. And they're trying to stop us from these treatments. They're through their bureaucratic setup, this takes 30 years instead of 2 years, right? So they blame the FDA, and I think it's actually having some impact on how these movements form and why we have these stem cell markets. Okay, so I don't have time to go through all of this, so I'm going to only touch on the ones that I highlighted in yellow. Is that yellow? So I'm going to talk about the clinical innovation idea, jurisdictional confusion, and this extraterritorial thing. But as I go through this case, you'll see elements of the other things I've talked about pop up in the case I'm going to discuss. So the case I'm going to talk about is this case, US and Regenerative Sciences LLC, which is a case that was initiated by the FDA to try and stop this company from promoting unproven and unapproved stem cell therapies. And the FDA was successful at the district court, I believe, the lowest level of court, and then this was an appeal. I'm not familiar with your court system. It's a product regulation and misleading labeling case. Now, this aspect is interesting to me because FDA is claiming you are providing and promoting a product which we ought to regulate, but you have not come to us to regulate it. That's the primary argument. But they're also saying the product is labeled as doing something it doesn't actually do. So that is the kind of truthful advertising idea I'm interested in. However, as I said before, the FDA first has to get through this one to get to this. To invoke the labeling requirements, they must first establish that the impugned product, what the company is providing, is in fact something that the FDA ought to regulate. This, I think, is a problem with the FDA's authority. Each time somebody says, I've made something called stem cells that can cure all kinds of diseases, the FDA has to first show that that's a product that they regulate before they can say you've made false claims. So they have to go through that product regulation route to get to the idea of truthful advertising. The other thing I don't like about this approach, and which this case highlights, is that the FDA has the burden of proof. The FDA has to actually show that this is a regulated product. It is because they're the ones making the argument. The other guys are saying it's clinical practice. It's not even a product. It's clinical innovation. FDA is saying it's a product, so FDA has the burden of proving that it's in fact a product. So this was the argument that the appellants made, the clinic made. They said the mixture is not subject to regulation under the FDCA, which is the act that the FDA acts under, and the Public Health Services Act, because it's neither a drug nor a biological product, but is rather a medical procedure. This is the guts of the argument. The court rejected it. The court said, no, it's a product, right? But this argument comes up all the time. It's come up in Canada. It's going to keep coming up. And I don't even think this ruling is going to make it go away. And in fact, it did not. As I'll show you, this company still exists. And they're still actually advertising this as a product. They just simply ignored the court and the FDA. In Canada, we've had the same kind of issue, as I explained before, with physicians saying what we're doing is clinical practice, it is not a drug. Now, the other thing that came up here is the idea of jurisdiction. So the appellants argue that because it's clinical practice, that is something for the state of Colorado, where they are based, to regulate. It is not for the FDA to interfere with federal authority, with state authority to regulate clinical practice. The FDA, as part of the federal government, should stay away from this. The court also rejected this argument. They said, look, the FDA is not trying to, they're not making the claim that the procedures you use, your practice around the product is bad. They're saying the product itself is the issue. The product, this thing that the FDA ought to regulate is the issue, and that it's unsafe. And because of that, they're not challenging the state authority to regulate clinical practice. They're simply saying, what we regulate, we brought under our authority, and we think that that thing is unsafe. There's a ton of federalism, we call them federalism arguments in Canada, federalism state arguments in the case. I think for those of you who are interested in that, you should read the case. But they also say, look, the FDA is set up to provide a comprehensive, uniform scheme for regulating the distribution of drugs, even by physicians, right? So the FDA has proper authority in this arena to regulate. So, in Canada, we had a similar debate. As I explained before, physicians who are trying to do this say it's the practice of medicine, not products. I expect to see a challenge at some point because Canadian physicians are mobilizing. They've recognized that this is an area where they can make money from. These treatments are actually very expensive, and they target populations that will spend the money. And so, wherever you have money involved, people are going to want to do something to get that money. And I think Canadian physicians are mobilizing. I got a consulting call a few days ago from a law firm where one of their clients who's a physician is asking, how do I get into this market? So they don't actually care what Health Canada says, they're going to want to get there. All right. Now, with this case, I think this case is actually a very good case. It's a 2014 case, says FDA has authority over the product regulation side. FDA also can regulate the labeling of these products, and there's no jurisdictional issue. With that said, what has happened after the case? These issues still linger. It's as if the court didn't actually say anything. They just simply ignored the ruling. So here's some examples. In Texas, they actually enacted a law that will potentially allow access to these therapies for patients who are terminally ill. And this is a law that came about from the lobbying efforts of a company that was set up in Texas initially called Celtex. It was the company that treated the governor at the time. He had issues and he went to this clinic and he got treated with stem cells. This was in the news everywhere. And this company has been lobbying for these stem cell treatments. The company was shut down by the FDA. They moved to Mexico. They just moved elsewhere and set up operations, but they've been wanting to come back to the US, and they lobbied for this law, along with patients who want to get access to experimental treatment. So the Right to Try movement was involved in this as well. Here's the legislator who proposed the bill, explaining what the bill does. He can do it better than I can, so I'm going to just play the video for you. If I can figure out how to.
These are tricky.
By the way, I just Googled stem cell treatment Salt Lake. They're all over.
Yeah, they're everywhere.
They don't list prices, though. They will treat androgen insufficiency.
Thanks so much for joining us here in Focus this Sunday. I'm Elizabeth Janelle. The topic of discussion this week, adult stem cell therapy treatments. For some Texans living with terminal illnesses or severe chronic diseases, these treatments can be life-changing. But people never thought they'd eventually be able to receive those treatments here until House Bill 810, known as Charlie's Law, passed during the 85th legislature. And to talk more about this law is a man who authored it, State Representative Tan Parker, a Republican. Thanks so much for being here today.
Well, this was my pleasure. Thanks for having me.
Certainly. So why don't we start by having you tell me who this law was named after and why?
Absolutely. So I named the bill Charlie's Law after a dear friend of mine. In fact, the first chairman I really served under in the legislature, a guy named Charlie Howard from the Sugar Land area of Texas. Charlie was an amazing man, great Christian man, battled cancer for many, many years. He had a multi-year battle with cancer. And literally, when we were in session in 2017, he and his wife, literally at the end of his life, literally came to the Capitol and were lobbying for my bill. Didn't even tell me they were doing it because the folks in Houston told him that his best shot at a chance at living was adult stem cell therapy and my bill that allow, if you will, the treatment to take place in Texas. So it was an incredible blessing and that they were there. And unfortunately, Charlie passed very shortly after that time. And so without any question, Charlie was the extra impetus that we needed to get this thing done. And so I was honored and very blessed and privileged to name it and honor my good friend Charlie Howard.
And you know who else gave emotional testimony on this was State Representative Drew Springer. We saw him get quite emotional last year, sharing his family's personal struggle and why he thought this law needed to be passed with a deadline looming there that night. Let's actually take a listen to that if we can.
Absolutely.
And I understand that other people are mad that their stuff had to be heard, but I'll tell you what, I'd trade every one of my bills I pass, every single one of them, to get the chance to hear HB 10. Because I pray to God every time I go to Mass, every time I close my eyes, that one day, my wife, and not for my sake, but for her sake, I have the chance to have that opportunity again, to be able to walk, to be able to come down.
Yeah, it's just so hard still to watch that. Just so emotional. What was that like for you sitting there hearing that?
Well, it was incredible. I mean, right before Drew went and went up there, it was an interesting deadline, as you just referenced.
Right.
And so we were talking about it and just kind of frankly praying about what would happen here as we came up across that deadline.
Yeah.
And so, Drew's one of my dear friends. We worked very closely on a lot of issues over the years. And our wives, in fact, both have had medical challenge. And so that's the reason where my passion comes from is my wife's health challenges and struggles and researching various breakthroughs. And so I was able to educate Drew on what was going on there. And of course, Drew and his wife, Lydia, then have tremendous hope that it can be beneficial to them. Lydia has a spinal cord injury. And so that's where it was very, very emotional, very personal for both of us. And so to be there on the floor and to see, one of my best friends deliver that message and talk about he and Lydia and their struggle that was so similar to my wife and I's over the years. It was very, very powerful.
We're going to hear from a number of women here in this show who, before Charlie's Law was passed, had to travel actually outside the U.S. to get these treatments. So could you explain really how this can change someone's life now? Yeah,
absolutely. Well, that's exactly what happened. So we would allow, the FDA and our policies here in the United States have allowed for the banking of adult stem cells. So you're able to take a sample and then be able to, do some type of work with those cells here stateside over the years, but you weren't able to then put them back in your own body, even though it's your own cells, unless you went out of the country. And so that's really been what the norm has been for now a number of years. And so with this legislation now, we of course passed the bill there in the 2017 session, and now we've been working this year with the Texas Medical Board and the Department of State Health Services. Those are the two entities that I gave, if you will, regulatory oversight over the program. So we want to be able to regulate ourselves here in Texas. We don't need Washington to regulate us. We can do it ourselves in a very responsible and appropriate manner. And so now, as a result, my hope is that in the fourth quarter of this year, Texans will have the ability to get these life-saving, life-altering treatments right here at home.
Wow, that's incredible. What about, right to try laws? Many states have passed that, I believe more than 30 or so. They're supported at the federal level. How is that different? Is it similar? Could you explain?
Yeah, absolutely. Well, right to try, of course, has been passed now in over 30 plus states, and very blessed that we got that done in Texas in years past. It was a major effort. What we do with right to try is to help people specifically that were terminally ill to have access to life-saving therapies, right? So what we're really talking about there are traditional biologics that, a top flight pharmaceutical firm is developing or what have you, and enabling, if you will, a faster process and access for those that are truly terminal. That's really what we did with Right to Try. Of course, President Trump talked about Right to Try in the State of the Union earlier this year.
Yeah.
It's a major initiative, obviously, now at the federal level, so we're excited about that. But what we've done with Charlie's Law in particular is, it's really in many ways an extension of Right to Try. It's not just for the terminally ill, but it's also for the chronically ill, which is a big additional benefit, I think, to Texans. And then we specifically, obviously, focused on these therapies around adult stem cell.
Certainly. Anything else you'd like to add on this topic, or anything you'd like to clear up? Or?
Well, look, I'm just really grateful, Elizabeth, for the time you're giving to allow Texans to hear more about this.
Yeah.
It's a really spectacular thing. Like I said, I feel very blessed that we were able to get it done, and my colleagues were so embracing of this concept.
Right, we gotta move on. So there's so much in that video, to just unpack. It's just so much going on there. But this is not a movement to sneer at. This is very well politically supported. It's in your State of the Union address. It's huge in the U.S. And what I want to highlight is that this is changing how we regulate the entry of drugs into the U.S. market. I think ultimately what you're going to have is two systems, really. One run by the FDA, and one that is run around all kinds of treatments, legitimate or questionable, that patients want. You saw the personal stories that got these two legislators to move this bill, their passion for it, someone crying on the floor of the legislature. These are very powerful movements that are based on personal experiences, and I can't fault that. But what he's describing in this video, the notion of taking stem cells from your body and putting it back in your body, has just not been shown to work. That's just the bottom line. So again, if you think about why we make laws and what kind of laws we're going to make, you have to ask yourself, if you allow this, you don't need law for that. And just simply tell people to go get whatever they want to get. But if you're going to have laws, there should be a reason for why you have those laws. And I think those reasons are supplied in two statutes that are implicated in that case. And those two statutes will find that these two things, whatever is going on with Charlie's Law, is not appropriate. Okay, here's the company today that was at the heart of that case, the product regulation case. This is their website today. This is even better than it was before the case. I've been tracking this company, and I could do an entire talk on this company. They still offer the same treatment for the same conditions today. They haven't even bothered to change their marketing on the subject. It's a very cool website. If you go on this website, you want to get stem cell treatments if you have the conditions listed. Now, a quick side note: when the Charlie's Law was passed in Texas, one of the benefits that was identified by even scientists in Texas is that it's going to give scientists a lot more data. This idea is an idea, actually, the second philosophical idea I want to throw out here today. It's a notion that came from those early studies we did when we talked to providers when we looked at what providers in places like China were doing. Some of them pitched this as, we can't wait for science all the time. Science is not always going to be from bench to bedside. Who came up with that idea? What kind of crazy idea is that? Do experiments first, and then try it out to see if it will work in humans before you make it clinically available. That's nuts. It can't be the only way. We can reverse that process. We can stick it in patients and see what happens. So that's the bedside to bench idea. And that's what's implied in this statement. If you put it in them, it will give us more data. It's an idea I'd like to talk about during the question period. I think it's interesting. Okay, so last thing about the FDA. All of this has had an impact on the FDA mandate. I'm sure you know about the 21st Century Cures Act. This is an act that actually allows patients to have a right to try early access to therapies, and it's changed the way FDA regulates. The FDA has created an entirely new classification for certain regenerative medicine products, and patients can now have expedited access to these treatments. So there's actually something of consequence that came from all of these movements trying to force product regulation to work differently. I don't think this is a good thing. I think it's actually probably one of the biggest mistakes the US has made in a long time, is creating this process, because I don't think it's going to solve anything. It's just going to embolden people who want to create markets where they actually provide things that are not legitimate. Okay, in 10 minutes, let me tell you about the model I prefer. So the FTC Act governs and applies to health claims broadly, so you can regulate any claims that are made in this arena. The law is broad enough to accommodate and regulate any unfair or deceptive trading practice. This is actually what the FTC is there for. If you make any claims about products that are not true, the FDA doesn't have to prove that it's a product that they regulate. They just have to show that the claim is false, right? It's actually a very simple idea. You can't promote things that are misleading, that are deceptive, or engage in unfair trade practices. And every jurisdiction, well, not every, most jurisdictions, most countries have laws similar to this. Canada has a law called the Competition Act that deals with this as well. It is not subject, this law is not subject to the clinical innovation challenge. Whether you're practicing medicine or you're selling products, be truthful is the idea. It's a very simple idea. So you can't throw it at the FTC and say, oh, it's just practice of medicine. Well, if you're practicing medicine, be truthful in the way you're doing that. It is also not subject to jurisdictional issues. The FTC's jurisdiction is pretty well established, both in legislation and case law in the US. I don't think you're going to get away with the kinds of jurisdictional challenges you saw the FDA face. It is also better equipped to deal with the issue, as I will illustrate in a second with a case I'm going to look at. But what you do need is consistent enforcement. I don't think the FTC has actually been as forceful as it could be in this area in terms of enforcement, but that's something it could think about doing. Okay, here's the case I'm going to talk about. This is a case very recent where the FTC sought a permanent injunction against this company. This company was promoting stem cells for all kinds of things. So the FTC sought a permanent injunction to shut them down and seek damages for the claims they've made and for all the patients they've duped. So the FTC was actually seeking money to compensate the patients that they have duped. Now, the interesting thing about this, and this is something that's actually one of the challenges with this pathway, is it's complaints driven. Typically, FTC waits for consumers to tell it what is going wrong, and then it acts. This is actually initiated by the FTC. That's what makes this really interesting. This case was FTC saying, well, we're going to make an example of these guys because we don't like what they're doing. This was initiated by the FTC. Now, in a nutshell, what the case says is that the respondents, this company, is enjoined, stopped from promoting or offering for sale or distribution. That's supposed to be all, sorry. Any covered product or service. So any of the products or services that the FTC is challenging, they can no longer promote or sell those. So what are the covered products or services? Well, this is the company's website before the FTC acted. As you can see, this is the kind of thing you see in this market. They tell you, welcome, which is nice, to where miracles happen every day. This is ridiculous, right? I mean, this is medicine we're talking about. They're not miracles in medicine. So this is very powerful messaging. If you focus group this, a lot of people are going to buy it. It doesn't matter how well educated you think you are. If you have a medical problem, this is going to sound good to you. And then they tell you what they're going to do. Stem cell therapy, IV therapy, PRP therapy, bogus as well. Bogus. 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 But it all looks very sciencey. They will solve all these problems. This is from the exhibits filed by the FTC. It's crazy. What is that? What is that? Does anyone know? I don't even know if it's the thing. Anyway, it's up there. You can get that resolved. You can get a loan. This is from the website. If you can't afford it, you can get a loan because obviously it's not covered by any insurance. You can get a loan if you can afford it. And then they have testimonials. Videos taken from the BBC, not even from their own patients. This family posing with this guy, not sure why, and a child in a wheelchair, and received cerebral palsy treatment, and then the same BBC video for autism as well. This is the kind of thing the FTC saw and decided to act. So, what did the court say? So the FTC says, look, they're offering all of this stuff. It is completely bogus. We want to shut them down and order monetary damages. Now, pay very close attention to what the court actually did here, because this is actually the kind of enforcement you want to see. It is very robust. It is the kind of thing you don't see with the FDA action against regenerative sciences. So you're prohibited from making any health-related claims without science, essentially. You have to get the science substantiated. If you don't have that, and it's not the FTC that has the responsibility to get that science, it's you, the person who's making the claim, who has to show that what you're claiming is scientifically backed. And they say, look, just in case you do not know what kind of testing you require, this is it. The scientific standard. We're not saying, get us copies of a 20th century book or, some patient testimonials. You need double-blind, randomized, placebo-controlled trials, and you need to have it done by people who have the experience of having it done. Now, something else I want to talk about during the question period. If we accept that there's a better standard, we should legislate that. Well, this is the standard. This is the current standard of the best available evidence. And if it's in the law, we should at least enforce it. The company was also prohibited from making health-related claims that are not backed by FDA approval, which is great. This is the kind of thing those of us who work in this area have been hoping for. A definitive statement that says it is not just about being scientifically proven. If the FDA has not sanctioned it, then you can't allow it. Now, here's the problem. Now we know the law has changed. The FDA might start to approve some things that are not actually ready for the clinic under the 21st Century Cure Act. So I don't know how this is going to play out, but this tells you about the problems with the FDA side of things and how it might filter down to this area. They also address the bench-to-bedside or bedside-to-bench issue I highlighted in Texas example. So they say the defendants, if they do engage in science, have to keep records. There's an order for record keeping. They have to preserve your records so that it can be reviewed both by the FTC, by the court, and by scientists. They have to produce and preserve any records of competent and reliable studies of clinical trials. And they say, look, if you have the option of going the scientific route, but document it, and you have to show it. And we don't want you to show us anything out there. We want to show us stuff that conforms, again, with randomized, double-blind, placebo-controlled, the scientific standard, which I think is great. It's saying, look, you're not going to stick it in patients and watch what happens. Do it the proper way. You have to do animal studies and then go to human clinical trials and document all of that. You have to provide a notice of the order to patients past and present. This, I think, is great. This is the kind of thing you're not going to see with FDA action. You have to tell everyone who's a patient that we've ordered you to stop. You have to send them a personal notice, letting them know that you've been ordered to stop, and you have to report to the FTC that you're complying from time to time. This is an order that's going to follow these persons personally, if you read the order, throughout their lives. Any business they engage in the future, any LSs that they come up with in the future, they have to report back to the FTC. This is a very well thought out order. The FTC has the authority under this order to do random checks, so they can send their agents there and do random checks at any time they want. They can even claim they're not from their patients and go in there surreptitiously and gather information. And this is the monetary award. It's quite 3 million, quite extensive. But the defendant said, well, we can't pay that. We don't have any money. We haven't made that much money from stem cells. So they said, okay, what can you pay? They have to do a disclosure of their financial statements and all whatnot. And the court said, well, pay everything you can. But you have to pay it in 6 months. And if you don't, the full order applies. So it's no surprise, and this is notice that I have to send to patients. Basically saying, we have to stop making these claims. We have to stop claiming that stem cell therapy is comparable or superior to conventional medical treatments. This is exactly the kind of thing that those of us who have been working in this area are hoping will happen to these clinics. All right, here's the website of the clinic today. Different from what you're going to see with Regenix in the FDA case. They have now simply limited themselves to other burger stuff, but not stem cells. None of this stuff works. It's all crap. But that's not what I'm here to talk about today. All this other crap is okay, but at least as far as stem cell treatments go, you're not going to find that on this website. This order actually worked. All right, so to sum up, FTC has a direct route to enforcement, which bypasses all the objections I raised about the FDA. It avoids the jurisdictional issues. It is a legally well-established pathway. I read, in preparing for this talk, I read some really cool US cases on the FTC's authority, some from 1940s, with some really cool quotes that I could bore you with. But from a lawyer standpoint, they sound really cool about the FTC's authority, and it's actually very well established. The consumer protection emphasis is consistent with the right to try movement. I think this is really important. If you said to someone you can't have this product for your illness, they're going to fight you. But if you say, look, it's a lie, somebody's lying to you, and they need to tell you the truth, they might actually stop and listen to you, right? So I think it's not antagonistic to this right to try movement, and it's a better way of approaching the issue. As you've seen, the remedies are more robust and effective because they did actually shut down that clinic. And I think for those of you who read my paper, the FTC has better means of taking this outside of the US through cooperation agreements that they have with other countries. All right, I did do 1 hour. I'm going to stop there. And thank you for listening. And I'm happy to take your questions. All right, okay. Go for it.
Thanks. So this is interesting. I'm George Contreras. I teach here, and this is an area that's interesting to me. I guess I'm not convinced that there's not a dual role for the FTC and the FDA here, and I'm not even sure. I think you're convinced of that.
Right.
Right. I mean, you keep referring to these treatments that are unapproved, right? But the notion that something is unapproved means there's an approval agency, and that's obviously not the FTC. And you're thinking of the FDA, as is the FTC in its own order,
Right.
referring to, these fraudulent clinics. They're not doing anything that's approved by anyone, but that presupposes that there's an approval agency, and that agency in this country has to be the FDA. The fact that there's a jurisdictional and a statutory issue around FDA regulation is true, but I think you're too late in arguing the product versus medical treatment distinction. Not in stem cell therapy, but in CAR T therapies, and the FDA has been approving things like Chimera and Yescarta as products, even though, and I've written separately in the patent area, they're not products, they are processes. But it doesn't matter, they're still approving them, and they've taken that jurisdiction on, probably appropriately, because somebody does need to regulate. And the Federal Trade Commission is not a regulatory agency, it's an enforcement agency. The FTC does not have the kind of medical and scientific expertise needed to regulate an industry. It's, again, these crazy fraudulent things, this is what the FTC does.
Right.
And again, you're standing at the heart of the fraudulent nutraceutical and fake supplement industry right here in this state, right?
Right.
This is where it comes from.
Right. So
we know all about FTC enforcement against these types of companies. It's been happening for decades.
I actually think we're in agreement with each other. I'm not arguing that the FDA role is not necessary or should be dismissed. I think they do have a role. What I'm saying is, first, the focus on the FDA being the lead in this is what I disagree with. Right? I think the FTC should play in the lead. But more importantly, I actually don't think there's a product for the FDA to be concerned about. I think these things are pitched in such a crazy fashion that all I see is false advertising, right? So if I put up a lemon stand in front of my house, a lemonade stand, not a lemon stand, that would be crazy. A lemonade stand in front of my house, and I say it cures cancer. You could try to prove it doesn't cure cancer, or that it's a product, you get involved in that debate, or if you just tell me I'm crazy and shut it down, right? I think these things are as obvious as a lemonade stand that cures cancer. That website does not suggest anything the FDA should be interested in. That's not, because
But as you said, I mean, so these companies are going to wise up, right? I mean, the first round is just outrageous, spurious claims, but they are going to get more sophisticated.
I doubt it. Because we studied from 2005 and the investigation hasn't changed.
Have, right? The nutraceuticals, they no longer make such ridiculous claims, right? They still imply that they cure all of this stuff.
Right.
But they're more within the boundaries of the law. Just one more point that is, with your argument of the dead letter, I mean, I think that overstates the claim. Laws don't exist to be enforced by the government. I mean, we have private enforcement here, right? We have, private civil law, tort law, and a lot of the medical cases that arise, in the legitimate medical world, come out of tort cases as opposed to enforcement cases. And just because you don't have an agency actively enforcing the law doesn't mean that the law is meaningless or that it's empty.
No, I was talking about enforcement from a regulatory standpoint. I'm talking about enforcement, the idea of enforcement. Even in tort law, from the notion that you have a law, you want it to have effect, right? And so courts can enforce the laws, right? Laws can be enforced by private agencies. I'm not limiting it to anyone. I'm just saying the only reason, right, to have a law is because you want the law to actually perform a role in society. It's sort of a broader philosophical argument. It comes from probably reading too much about what elements should a law have for you to call it a law, right? The argument essentially is, if you call it a law, it has to do something different from our intuitions. It has to do more than our intuitions. If our intuitions are enough for the matter, why do we need law? If we can get along with one another, working with our intuitions and cooperating, I don't think you need something extra, right? Now, I think in this case, the idea of enforcement I'm thinking about is something much bigger than the notion of unregulated or another. It's just the idea of having a law that, in practice, is not doing much to change the behaviors identified as a problem.
And it may be because the people who have bought these fake treatments haven't been aggrieved enough to bring suit yet, right? I mean, some of these people believe that they have been cured, right? I mean,
I wouldn't look to them though. I mean, we're gonna talk about this offline, but I wouldn't look to them to be the ones trying to enforce this. I mean, you couldn't look to the people who are most unable to actually prosecute the matter for a variety of reasons. To be the ones who are. I mean, again, we have the rule of the state. The state has two agencies that can look at this, as you have acknowledged, and I think they should be looking at it. Is the argument. Well, we can talk about it more. So I can take some more questions. Go ahead.
Tennille, and then I'll go to students.
Oh, we can have students first.
Oh, it's okay. Well, so I was wondering if you had thought about, because I don't know if Canadian provinces have their own like law enforcement agencies, but like in states we have state attorney generals who generally have broad consumer protection authority within the states.
Right.
And sometimes states even have stricter consumer protection statutes for the FTC. Have you thought about maybe there's a role for attorney generals to play, like maybe California, which seems to have a lot of these, but they also have strict consumer protection laws as well? It seems like it would bypass some of these jurisdictional issues as well.
Yeah, possibly. Yeah, I think that's a good suggestion, actually. I don't see why I don't mean to imply that only one government agency should be dealing with this. Right. As many as possible is great. I just think the FTC in that example has shown the way. And what I'd like to see is more enforcement that looks like that. And I don't necessarily care where it comes from. I just don't think it's going to come from the FDA. So if the states want to pick up on that and enforce that way, in Canada we have, the states don't have a role in this. It's something that's regulated federally. So it will be the Competition Bureau in Canada that will be looking to do this. And they haven't done as much as this. And I think the FTC has really shown us how to go forward with this. What I'd like to see is more agencies, whether private or public, take up on this. But I don't think the FDA is necessarily going to get involved in this.
Chase?
Professor Brown, I defer to you.
Oh, I think it's really insightful to focus on the political realities of the Right to Try movement, what motivates them, and to try to counter that with the idea that we're not withholding something from you because we're big brother paternalistic government and we know better how to regulate safety, but that they're lying to you and that there's a deceptive unsubstantiated claim, and that if they can prove that and clear that, then you can have access to it. I think that's actually really smart. That's probably the most insightful part, I think, in the whole presentation. There were a lot of insightful parts, but that's the part that really stood out to me, is like, that makes a lot of sense. But I'm still concerned about the FTC prioritization over FDA because of the idea of waiting until the harm occurs.
Right.
Instead of pre-market approval. We're better at making sure this never gets to market. And I think that even though they're sophisticated, they're still making structured function claims that would clearly be within the ambit of FDA if they chose to regulate this. And that solves the problem before the harm happens, which is real, significant, and financial for a lot of people that are bankrupting themselves to pursue these unproven treatments. And everything, of course, hinges on the fact they're saying it's therapy, but it's not therapy because it's not proven to be therapy. But also the other side of the political reality part that I think is really important to take seriously is the idea that we live in a state that under-enforces consumer protection, and there aren't a lot of private rights of actions outside of torts which have their own obstacles for people to bring claims, lots of financial and other access to justice problems. But if you don't live in California, you're not going to have your consumer rights protected because the nutraceutical lobby is so powerful here, and we don't have a strong consumer protection force. And so I like the idea of it just never being allowed to come to market, rather than having it be after the fact and hoping that there's political will to enforce these consumer protection statutes.
So, right, I mean, I agree that those are objections you could raise to the consumer protection idea. I do think that that's what we're seeing in Canada. We have a consumer protection agency that doesn't really act unless a consumer complains, and then they don't do much after that. But I think we're way past what I think the FDA has the same problems. What I'm trying to say, the FDA has not
They
actually
have an
managed
agency capture for sure. I mean,
Right.
there's the argument there that at least MTC may not be as beholden to an
Right.
industry.
So if you put aside the arguments I've made against the FDA, they have actually not succeeded in stopping the proliferation of clinics. So we're seeing the market even grow bigger. So I don't think
They could issue injunctions though, right? It's possible. They just didn't in the one case, but they could.
But even with all that they've been doing, the clinics keep expanding. And as you suggested, what's happening is these clinics find ways to keep, they find ways to get around the FDA's authority. And that's because the FDA is trying to say, look, it's trying to pin them down to, this is a product we regulate, right? So all they have to show is we're not doing something that is caught within what the courts have said or what you've said before. We're just doing something different now. Now, maybe all of that wouldn't matter if these clinics actually cared. Because what they're doing is they're targeting people who actually also believe that are being helped by this. So there's actually a sort of a big political lobby as well as coming from patients and from right movements to keep them in the states where this argument keeps coming up and the FDA can't touch them. So I guess I'll accept the product regulation route if it were actually working. I do acknowledge that the FTC has limitations that maybe the FDA doesn't have, but I think practically speaking, it's probably the same. And as I noted, I'm not convinced the FTC is taking enough action. That one case highlights what they could do, they did take action. But as I noted at the beginning of the talk, and at the end, I am not sure it's a solution that's going to work either, right? That's why I say it's all dead letters, because the FTC is not doing enough of those kinds of actions. They've gone against one company. I don't know what effect that's going to have on other providers, because other providers are still out there making these claims. So both organizations seem to be caught in the same bind. I just like the way the FTC has gone about it because it's less subject to the kinds of attacks that the FDA gets. So I guess I'm saying in theory, the FTC approach works better. But practically, I accept what you're saying, that both of them have challenges.
Chase?
Yeah, so I have two questions. The first one is just a yes or a no. So you're a self-proclaimed pessimist, you mentioned.
Right.
And you used the word bogus several times.
Right.
In your personal opinion, is there any hope for stem cell therapy in the future, becoming an effective treatment?
Gosh, you're good. You want a yes or no for that?
I guess, or a maybe.
But the witness is directed.
All right. I'll go with a maybe. but leaning very strongly towards the no.
Okay.
I actually think stem cells are the most hype thing I've ever encountered in medicine. It's just, I don't know that it's going to become clinical standard of care for everything we hope it's going to become. For it might be useful, it's already useful in the bone marrow transplant context. It might be useful for some things, but the idea that it's going to do what we say it's going to do, which is change the way medicine works.
Miracles.
Yeah, I don't think that's possible. And that's not a message that's coming from this industry alone. It's come from the US government when they were promoting stem cells initially. I can show you quotes. No, actually, I have them here. I will show you the quotes. All right, so this is from the US Department of Health and Human Services. Yes, virtually any disease. They call it tissues for life. This is government messaging. You know, it's not. This is where this language that these clinics are using comes from. You know, it's this is not going to happen. I'm a firm no on this. I think stem cells will have a role to play in medicine, but not this. I haven't seen any kind of, except for vaccines maybe. I don't think stem cells are under vaccine.
All right. So assuming that stem cell therapy will be better at some point, even if it's just a little bit, adding these additional burdens or like getting the FTC involved like your paper suggests, do you think it will hinder that progress or slow down?
No, because the FTC won't have a role to play if the treatments have been shown to work. The FTC doesn't, they don't have a role to play right now for treatments that are in the clinic that have been shown to be safe and effective for the conditions that are being used for. The FTC has no jurisdiction there. They only have jurisdiction when you're making a claim that is deceptive, unfair. So the FTC role will not be implicated in any way, and I don't think it will be a problem. What I see as a problem is when this gets tied up in litigation from patients who have been harmed by this sort of treatments, and we then have courts actually getting in trying to regulate as well what's going on in this arena. And ultimately, you're going to have so much noise around this that it might actually not make any sense for anyone to continue the research and development because there's just so much going on in terms of how to get a product to market in this space. So I think this is actually going to end up affecting the market, and it's already having an impact on the market. It's having an impact on the way science is done. It's having an impact on the way you think about getting to drug approval and getting through that process. And what you don't want to see is a process where at the end of the day, people don't want to invest in it because there's so much risk associated with litigation and maybe loss of public trust in the therapy. I think that's what it's the opposite as I see happening, not that the FTC is going to have there's going to be too much government intervention when you have the real thing.
So I got a related question, I think, which is, whose job is it to let the FTC know that they're deceptive claims?
All of us. Anyone can. You can actually just write to the FTC now and say, look, I found some clinics in Salt Lake City, and here's what I think they do. Anyone really can make a report to the FTC. But I also think consumer protection agencies should play a more active role in actually fishing out some of these things because they do have that authority to initiate this. They shouldn't just rely on consumers to report this. What I'd like to see is more active enforcement in that direction as opposed to consumers saying this is what it is. At our group, we've thought about actually just having a website where we just report these claims and just ask the FTC to visit it all the time.
Yeah, my question, so I Googled just very quickly how many cases the FTC has brought against supplement companies that make these false advertising claims, and it seems to be very low, a couple hundred cases in the past decade. Do you feel like this is a different problem that should be treated separate from kind of this supplement claim? And if so, why? And how should the FTC treat those differently?
Right. So I don't personally think it's a different problem, but it's a different problem in practice. The reason for that is that there's actually, within the supplement industry, that is treated as a product that can be regulated and is regulated in certain ways where the standards for showing it's a product that can be used by consumers is much lower than you have for a conventional drug. And so the bar is really low. What the FTC is trying to do is to say, stay within that very low bar. Don't go beyond it, right? So I think you're seeing the number of claims there because the FTC has to tread very carefully. They have authority. No, they have. These supplement companies can sell supplements because supplements are legally regulated products. I don't think most of them do anything. But anyway, they get approval from the FDA or from Health Canada. You can sell them. The issue is, can you make certain claims when you sell them? So if you take, for example, one of my favorites, like homeopathic products, which do nothing. They're sold in stores, but they get a seal of approval from, say, Health Canada, which slaps something called an NPN number on them. And they make the claims that it will help you for cough, right? Now, is that a false claim? Yes. But is a truthful advertising regulator going to pursue that? Probably not, because that's exactly the reason why they got the approval. Because they said, look, it doesn't work the same way as a conventional drug, but it's a herbal remedy that will provide some relief, right? But if they say, look, it's going to cure cancer, that's a different statement. So that's why you're seeing very few claims. The FTC cannot go beyond its authority to regulate. It only intervenes when they go over this very low bar. For this problem I'm describing, there is no bar. It is so outrageous that just looking at it, now maybe over time they're going to start to moderate these claims. They're going to start to, we're already seeing some evidence of that. So for example, they'll focus on certain conditions. They'll say, we only do arthritis, and we only spin your cells and put it back in you. Those will be more challenging. But they also don't have any evidence for that, right? So it's bogus. And there's also elements of the claims that they make where they target seniors and they put it in such a way that makes it seem, on the face of it, to be false. That's a very different problem from where you have a product that's actually a regulated product where they've gone beyond an advertising bar.
So I have a question about, you mentioned that there's doctors that are getting involved with selling this.
Right.
Can they be regulated? Or is there additional things that can happen with them?
Right. So I don't know how it works in the US, but in Canada, physicians are self-regulated, or they're a self-regulating profession. They regulate themselves. So they have a college that is made up of physicians that regulate physicians. Now that's a form of social contract, if you will. We as government and the people can't figure out how to regulate you because you're a technical field of expertise. So you regulate yourselves, but you promise us you won't do anything stupid. That's essentially how it works in Canada.
So in the U.S. there is state-level medical licensure regulation, and so practice of medicine is and a lot of before STEMSA, these clinics that did crazy, weird procedures that claimed to do miracles, but they didn't cross state lines. They were just in state, not regulated by the FDA. It was state medical licensure boards and practice of medicine claims that reined those in.
Right. So that was the argument you saw Regenerative Sciences making. Within the state, we're doing nothing wrong, right? Maybe that speaks to the strengths of the Canadian model, where we say, look, the state can't figure out what's going on, so you regulate yourselves. But the profession is not doing it either, because the profession, I think, plays to certain incentives. In this case, it's money. Those doctors charge about $2,000 per injection. You need 6 injections. For the clinic I showed you that they have to shut down in Canada, 6 injections, that's $12,000 being paid by seniors out of their retirement funds. It's not covered by our healthcare insurance system. So if you're a doctor and you make 6 injections, you get $12,000. Of course, you're not going to be against anything from your college that says don't do that, right? So those incentives, that's what's driving the way doctors regulate this practice in Canada. So maybe there's an argument for the state to intervene in Canada. And here, there's an argument for maybe the states to care more about what doctors are doing if it regulates doctors. But I think there's something missing from both models, and I don't quite know what the solution is. But that's the problem, is doctors, I think, tend to get a free pass in the two models, if you will.
Where some of that will come in is if it's not a doctor at all.
Right.
Practicing medicine without a license.
A license, yeah.
So if somebody, students sent me questions, and let's see, I've got a couple more that I'll just raise, and then we'll adjourn more informally.
Sure.
One, I think, goes along with Brittany's question, which is, are there other regulatory regimes that might be out there?
Right.
The SEC, the drug, could these be controlled substances and
Right.
drug enforcement, other, I don't know, but this was,
Right. So one of my fears that I had with doing this talk today is a foray into U.S. law, which I know nothing about. I think I've already done enough damage to U.S. law as it is, so I won't comment further on U.S. law. I think there might be other avenues for dealing with this, but I'm not expert enough to know this. I'll defer to any experts in the room to talk about what other avenues.
how about in Canada?
In Canada, I think what should happen in Canada is that our Competition Act should be enforced. So I think we actually have a deeper problem in Canada, which is that this argument has been made, this clinical innovation, clinical practice, product distinction has been made in Canada before. And the Health Canada typically backs away from the argument and decides not to fight it. I was actually surprised they released that statement. But I think if they were challenged in court, they'll probably fail. Because the thing with our system is, if it goes to court for determination, they're going to read the statute very strictly, right? And if the physicians are arguing that they're taking cells from a patient and not adding anything to it and just putting it back in the patient, that's purely a consumer protection issue. Does it work for what you're doing it for? No. Is it safe? I don't know. I don't have any evidence. But have you produced anything? I think the Canadian courts will actually say no to that. In Canada, what happens with federal agencies is they typically won't challenge things if they are unsure as to how they'll go. We have things like that in like the reluctance of federal government to challenge polygamy laws, for example. Like they wouldn't challenge polygamists because they're afraid that there'll be a reading that says polygamy is supported by our constitution, and then everyone will become polygamous. So that, I think that's the kind of thing you're going to see with Canada, which I think if you start early by saying this is a consumer protection issue, you might actually get at the heart of it. Because I think the one thing that everyone can identify with is that you don't want to be lied to, right? But when we start arguing about whether it's a product or not a product, someone might say it works for me. My mom tells me that all the time. What do you know? It works for me. Like, well, it's bogus. Like, no, it works for me. I can't challenge that. It works for her, right? But if I say, Mom, this person is lying to you, she might want to listen.
On that note, thank you.
Well, thanks. And this cured my cold too. Oh, I should say thank you to Cynthia. Where did she go?
She's coming back with the food.
Oh, okay, yeah, she's been fantastic. Thanks, Cynthia. Thank you. And I'm happy to answer any other questions you have.
I haven't looked at my phone. That's so strange.